Okay, I'm Lydia Hubble. I'm in Nashville, Tennessee, and I am fighting in a custody battle in juvenile court, which has been going on. It's been almost 4 years to the day since Sarah Rice, who's now Sarah Rice Digby, was retained by my daughter's dad, who I was never married to cut me out of my daughter's life. So, yeah, almost 4 years exactly. Okay, so we had an agreed order. My daughter's dad dumped me when I was pregnant, and he didn't know if he wanted to be involved in the baby's life or not. I wanted him to because I didn't want my daughter to not have a dad. And then people warned me, oh, you know, he's Turkish, he's a Muslim. Have you seen Not Without My Daughter? If you have him involved in your daughter's life, he will steal her, he'll run off with her, you'll never see her again. And I didn't want to make decisions based on speculation and worst case scenarios. I wanted to give my daughter an opportunity to have her father in her life if he wanted to be in her life. I didn't want to set up any roadblocks between her and her father. I never have, and I never will. I have zero regrets. I believe I did the right thing, and I believe I have to do the right thing as far as I'm able, whether other people are doing the right thing or not. That's me, and that's how I keep myself mentally and spiritually healthy, and I don't have regrets. I'm sorry that other people don't try to be the same way with me as I try to be with them, but I'm not responsible for them. They have to answer to God for what they do and their choices, and I have to answer to God for what I do. And other than having sex and getting pregnant with a man I wasn't married to and who I knew had emotional problems, but who I felt was basically a good person, and who has turned out to be a good father in so many ways. And I'm so thankful I didn't get myself in worse trouble, because there's lots of people out there who are a lot worse than my daughter's dad. And I love him, I respect him, I admire him, and don't really like him, don't really want to deal with him when he's hateful to me and hostile, but I know he's got issues, and I try to be patient and kind with him because he's got problems, and he's just not emotionally equipped to deal with some of the things he's had to deal with, and he's not healthy enough to go get professional help when he needs it. I'm so thankful I'm not too proud to go get help when I need it. So we co-parented for, I don't know why my light keeps changing here. We co-parented successfully for 5.5 years. My daughter was absolutely flourishing and happy, healthy, well-adjusted. I had her evaluated by the school psychologist in our public school system. She's academically advanced because all the work I did with her at home and all the opportunities I gave her, and she's intellectually gifted like her brother and sister. And I wanted to homeschool her, and I was pretty much, I mean, I was her primary educator. Her father had 2 days a week. He had her in private preschool, which those were his days, and I'd rather have had her with me, but because my older 2 kids never went to preschool, I did preschool with them, and they turned out great. And I would have rather had that parenting time to be with my daughter, but I let him put her in preschool 2 days a week from the time she was 2 till the time she was 5.5. And then I was going to homeschool her. I did enroll her in. I was a primary residential parent, and we were supposed to make joint decisions, but there was nothing in that. That's my mistake. I had a lot of reservations when we did this agreed order before she was born, but I did it anyway because I sort of felt like I didn't have a chance to or I felt like it was the best I was going to get. And I made some concessions I didn't feel comfortable with, and I told him I didn't feel comfortable with them, but I did it anyway. And but I was designated primary residential parent, but we had joint decision making, and that's where I messed up. I should have insisted on me being the final decision maker after consulting with him. But I don't know what else I could have done. I was really between a rock and a hard place, and I thought that would be good enough. I thought that would be good enough if and I didn't know how involved he was going to be, because he didn't either. He didn't know till she was born, and he just fell in love with her and got so attached. And but we like I said, we co-parented till she was 5.5, and then he hired Sarah Rice, who's now Sarah Rice Digby with Digby Family Law in Nashville, Tennessee. He hired her to cut me out of my daughter's life, and you only see, and I can only see from in hindsight how carefully orchestrated this was. I mean, I could see as things happened. He was acting in bad faith, and he was lying, and he was cheating, and I couldn't. I was really shocked that the lawyers even asked for the kind of I didn't think any lawyer would take his case because it's unethical, and I didn't think any judge would give him what he asked for, because it's harmful to the child. But anyway, so I'm just going to go ahead with this order. I've got some videos. I've got videos on YouTube. I've got that go back, and I've got anything in my case. Almost the only things I don't want to share with people are, there's just a couple of things that are about our sex life that ended up in the record. I don't think they should have been. I don't know why they wanted to put them in there, but it's not relevant to, it's just, it's not relevant to the custody thing. I don't know why they brought it up exactly, but anything else in the record, I'll let anybody say anything I want to. But not that. If I give you something, I'm like, well, we got that scratched out because it's really personal, and that's the only thing. Everybody knows I had sex with him. I got a baby with them, and I said it was wrong. And I've admitted that. That's my big mistake, is making that bad choice and putting myself in a situation when I knew I was not in a good state of mind, when I knew I was vulnerable, when I knew I didn't have my head on straight, and I got myself into trouble. And it can happen to anybody. Probably anybody who's lived 52 years has made bad choices that they've had to pay for. So that's, and you can't you can't really hide that. If you have a child out of wedlock, everybody knows what you've been doing, so you might as well acknowledge it, and that's what I did. And I've been celibate for many years, and I intend to stay that way. So that's the best I can do. I can't undo what I did 10 years ago. Okay, final order. This is the final order. So we had an agreed order, then we had a custody modification when he was trying to start cutting me out of her life. And then he won that because of his dirty tricks. And then I asked for modification after several material changes of circumstances. And we just finished it up, and this is the order we get. And the order, if you go to, I'm on Facebook, all this stuff's on Facebook. That's like whatever, I just got everything out there on Facebook. Bring Delara Home is the group, Facebook group, Bring Delara Home. It's public. And my Lydia A. Hubble profile, that's my Facebook page, is public. But on the Bring Delara Home, in files is my brief, because I had it in a Word document. But the appendix is I scanned every page separately and put it in photos. So it's like every page is like a photo. And I don't know how to do PDF things, or I could have just run the whole thing through a PDF thing. But so that's where it is. There's my whole case, if you're interested. And then the new stuff, I've put a lot of new stuff, this new custody modification trial. So, but if anybody wants to know anything, just tell me what you want. If you want to understand what happened and you think somehow I did something to deserve this, and my daughter deserves to be used as a weapon against me, or a tool, or, you know, it's just really sick. You're not supposed to be using kids like that. It's just sick. It's just, I mean, that's one of the sickest things I can think of. But anyway, so here's the final order. I'm just going to read it, and then I'll comment. This cause came to be heard on, well, I won't read all of it. And this order is uploaded. Lydia A. Hubble, photos. It's got its own album. So you can just go read it yourself. So, we started this custody trial in, okay, so we filed our petition to change custody again, or for a new trial, in November 16, 2016. That's when we filed. And this was after my daughter's dad had refused, 2 months, refused to let me have any contact with my daughter. He's violating a court order. So, and I hired Connie regularly, and she wrote up this petition. I went to file it, and I did an affidavit of indigency because I didn't have, I don't know, it's almost like a couple $100 to pay the filing fees. I didn't have it, so I did the affidavit of indigency, and when I did the affidavit of indigency, they had me do a pro se petition, which I wasn't sure why they had me do that, but that wasn't my idea. That was people at the court. They made me do that way. So we ended up having 2 petitions for contempt. It says mother's pro se petition for contempt for failure to comply with an order for visitation in a parentage case, and then they ended up throwing that one out because it was pretty much duplicated, and we dropped the contempt. And all of the hearings, I'm pretty sure every single one, every trial day, every recording of every trial day is on YouTube. Anybody can watch it. So we dropped the contempt because it was complicating things, and we'd already had three or 4 days of trial, or in court for, yeah, we had maybe 3. And I didn't have much money, and I lost Connie, and before these last, I was 4, we had 3, October, we had 2, May 10 and 12, and we had October 16, 18, 25th, and then February 9th. So those were our, so we had a trial over 1, 2, 3, 4, 5, 6. March 13th wasn't really a trial day. It said it says this cause came to be heard, but she had it taken under advisement. So unless she's claiming it wasn't taken under advisement, I got her on video saying, I'm taking this under advisement. But come back to check on something. So That might be how she tries to get around getting in trouble for keeping something under advisement for more than 60 days. Because we'd entered all our proof. I closed proof, he closed proof. Trial was over. But that's one of the things I'm gonna try to. I will file a complaint about her keeping that under advisement for that long, but we'll see what happens. Okay, let's see. So we filed to change custody, and he had before, I think he just decided not to let me have my parenting time, which was supervised. It was still supervised because I hadn't got official permission. I thought, according to the court order, and the court order is in my brief. Actually, is in the appendix which is in photos in my Bring Delora Home Facebook group. So what it was he got his order of protection against me, and that's on YouTube. I just couldn't believe it. It was ridiculous. And lied. He lied like the devil to get it. And his lawyer did too. And then the judge way abused his discretion. And you don't even if I had not, because Sarah Rice goes in there and she's like, she hasn't followed any of the court orders in juvenile court, so that's why we had to come to you to get relief. But that's wrong in the first place, because they did not ask whoever is making the orders, that's who you go to enforce them. You don't go to the higher court who doesn't know what's going on. And that's the order, but you had to go there to get the order of protection. He could have gotten a restraining order if he needed one, which he didn't. But he could have gotten a restraining order in juvenile court. But no, that wouldn't have suited his purposes. He went to Third Circuit Court, got this order of protection. He lied and said he had custody of the child and claimed all kinds of crazy stuff, like I was yelling and screaming and going to his house all the time and harassing him all the time and trying to get more time with the child than the juvenile court would allow. It's all lies. All those, yeah. There's some things. Yeah, I did. I called him. I mean, it's on there. It's like a 45-minute video on YouTube if you really want to know. But so we got the order of protection. In the middle of the custody trial, we had like a day of custody of the trial left, the first custody modification trial, because our first order was an agreed order. He agreed. We had 185. Yeah, and that original order is in the appendix of my brief, and you could see our agreed order that he had a lawyer. I didn't have a lawyer. He had a lawyer draw it up. We signed it, and then a couple of weeks after the baby was born, the judge signed it. And that's what we worked under for 5.5 years till he decided to cut me out of my daughter's life. So so he won the first custody modification trial because he went and got that order of protection, and the judge never knew. She never. I had already closed proof, and then when I tried to tell her about this other stuff, she didn't want to hear it about what really happened but so anyway, so he had that order of protection. It was supposed to expire in a year, and then after it expired, I was supposed to start getting supervised. I went from 185 days parenting time in the agreed order we had to 0 in the first custody modification. They didn't give me one single parenting day. Even after, because the way it's written, it's like, okay, well, you can have 4 hours a week. And then she always said he could give me more time if he wanted to. But he's not going to, because he wants me 100% out of my daughter's life. So why would he give me extra time? So she said, you get 4 hours a week, supervised visits, and then if that goes well and the agency recommends, thinks you're ready for unsupervised, you can get 8 hours a week of unsupervised. And then I think she said after that I would have to go file a motion to get more parenting time. I can't think of a single time in 4 years that they've granted my motion. The only time they let me, they put my daughter, when I stopped homeschooling, they let me put my daughter at my preferred school, which is the one in my neighborhood where my older 2 kids went. And when, I'm going to talk about when they non-suited this, I filed a motion to proceed, go ahead and have the custody trial, the trial when I was trying to get my parenting time back after they because they didn't want to have that trial, so they didn't want to have that trial at that time because they weren't ready for it. They had not prepared their case. They had not set things up to where they knew they would win, so they non-suited it, and then I pushed ahead. They claimed in their petition where they were made all these allegations, and they're like, well, the mother's mental health has drastically or deteriorated recently, and her physical health has deteriorated recently, and the condition of her house has deteriorated recently, and these are all materials, changes of circumstances. It seems like there's another thing or two they said was a big material change of circumstance. You only need one material change of circumstance, but they had a whole pile of them when they filed that, and then when they stopped me from homeschooling. But when it came time for the trial, they non-suited it because they didn't want the trial. Then they wanted that underlying motion for to stop me from homeschooling. They wanted to try to wean my daughter away from me. And then they were setting things up so that when they actually did have the trial, they could say, well, it's true that the mother used to be the primary caregiver, but since the child's been at school, the mother and father basically do this equal amount of caregiving. And that's exactly what they did. They took 800 hours a year of prime time parenting time, daytime parenting time, away from me, and gave it to the school. And then they used that to say, that bolstered their case. It was like, well, the mother's no longer the primary caregiver of the child. I think I still was, really, but they got that order of protection, so I was, then they really know, oh, the mother's not a caregiver at all. So it was very well orchestrated. But when they non-suited their petition, because we'd already had a court date set in December 8th, 2015, and I said, we got this date set. I've been waiting months to go in there and say I want my parenting time back and make me the final decision maker after consulting. I don't care if you say it's sole decision maker or final decision maker, because I wanted the father's input. If he wanted to talk to me and discuss something, I wanted his input but I wanted to make the decision because I felt like I could make better decisions than him. And then that was held against me. It's like, oh, you think you can make better decisions than the father, therefore, you've got problems. But I don't know what I'm supposed to say. When they say, why should you be the decision maker? Why wouldn't I say, because I've got more experience, I know my daughter better, I've spent more time with her, and I've got all this experience with my other kids, I know what my daughter's needs are, I've been meeting my daughter's needs all this time, and I make good decisions about her care, and there's no proof that I hadn't, unless you want to say I made a bad decision by choosing to invite her father to be involved. Maximum parenting time and involvement in her life. Then if you want to say that's a bad decision, you can say that's a bad decision. But I didn't think it was a bad decision. So we went ahead and had the trial. But then when we had the trial, all of a sudden they're like, oh no, there's no material change of circumstance. You can't change anything because there's no material change of circumstance. But in their petition that they filed, they said there was like 3 or 4. And at least 3. So, and that's a sworn, that plea, it's a sworn statement. And they didn't strike it, they non-suited it. So it's just like they set it aside and they can bring it back out in 12 months. So that's the number one perjury, I think. Why would you make a sworn statement and say, this condition, which wasn't true, is a material change of circumstance. This position, which wasn't true, I had proof it wasn't true, is a material change of circumstance. And, you know, all these things are material change of circumstances, and you swear that, and you make that representation to the court. And then when it comes time for trial, you say, oh no, there are no material changes of circumstances. There's zero material changes of circumstance. And that's exactly what they did. And the judge said, well, you haven't met the burden of proof, so he didn't change anything. And then I got a rehearing with the juvenile court judge, and that's the custody modification trial when he got the order of protection and all that stuff. So then when the order of protection expired, and then I filed to change custody in November 2016, we finished the trial February 9th, 2018, and final order came out April 19th, and I'm going to file a motion to alter or amend. I mean, it's garbage. This order is garbage. The first order she did was garbage. I mean, when I read that first order from 2015, it was final order in 2015, and I appealed it, and I just went all through my appeal. That's what, and I didn't address everything. When I first got it, I wrote down like 17 things that I felt should be appealed, but I'd heard that you shouldn't do more than like 3, because if you complain about too many things, they'll think you're full of crap, and then they won't take you seriously. And that's not true, because there's a case, Mashburn versus Mashburn. I think that's 2016 in Tennessee, and it was lawyers on both sides. And this side, I was pro se against a lawyer, but that Mashburn versus Mashburn, there were 6 things brought up on appeal, and they all got reversed. So that's an example that, you should, it's an exception to the, if you do more than 2 or 3 issues on appeal, they're not going to take any of them seriously, because they reversed all 6 of them. So, okay. All right. So, findings of facts. Okay, before the child's birth, this court entered a order. Yeah, that's the agreed order, the consent order of to establish parentage. We had joint legal custody and joint decision making, and it didn't spell out a parenting schedule. It just said he got 180 days, I got 185 days. I was primary parent. Joint decision making. There's like. Yeah, and that's in, that order is on Bring to Our Home under photos. Child's born October 15, 2008. On May 20th, 2014, like 3 weeks after he hired this attorney, father filed a petition to modify the consent order and asked to be named primary residential parent. Mother also filed Father also filed a motion to enjoin mother from homeschooling the child, because he couldn't file the motion without having a petition to, yeah. So they filed a petition, and then they had this motion so they could get action before having to wait months and months and months for a trial. Because they filed this May 20th. Father's motion came to be heard on June 30th, at which time Magistrate Scott Rosenberg enjoined mother from homeschooling and this is their allegations, due to concerns over mother's ability to provide the structure and organization required for education and due to mother's health problems. And that was another like 45-minute hearing, and I'm pretty sure I got that on YouTube. So like at 45 minutes, they stopped me from meeting my daughter's educational needs in the best way she could possibly hope to have them met. And that ended up being true. You know, I told them I can meet her needs so much better at home. And we had a guardian ad litem come in and check my house out, and we took her out in the house and the yard and stuff. And that was Rachel Welty, and she didn't say one bad thing about me. As a matter of fact, I mean, this was really the first court hearing I was really participating in, and I didn't really know what to do and question, you know, how to get my point across, or my, you know, except I had answered the motion, the allegations. I had done a written answer, but this guardian ad litem, I mean, she asked me all these questions, and I got things in front of the judge, told the judge that, and I kind of don't think they read these motions before the trial. Some people might, but I don't think they did in juvenile court. But yeah, so the guardian ad litem, Rachel Welty, she's like, well, tell me about your, so I got to tell all this stuff and all these details about my background working with kids and early childhood education, and how my daughter had just been tested and she's academically advanced, and all this good stuff. I wouldn't have got that in if she hadn't asked me these questions. But still, he enjoined me from homeschooling. And I did not have any new health problems. My health was better than it had been in months. And I am on disability. But I wasn't, just because you can't engage in substantial gainful activity, that doesn't mean you can't be a full-time parent necessarily. And it doesn't mean, because I had 3 kids at the same time I was taking care of. And it doesn't mean you can't homeschool, because to me, homeschooling is just an extension of parenting, because that's my philosophy and my educational philosophy, my parenting philosophy. And I knew all the different resources available and options, and I knew I could do it. And I knew that if it got to the point where I couldn't meet her needs better in homeschool, then they would be met in a different setting. We could always change. So I'm just like, I'm really in tune with my my kids and how well their needs are being met. And if there's, you know, if we need to do something different, I'll do something different if it's going to be better for my daughter. And that guardian ad litem, when they asked for a guardian ad litem, Magistrate Rosenberg said, well, it'll be $1,000 a piece. And I said, well, I don't have $1,000. And then my daughter's dad says, well, I'll pay for both of us. So they got this guardian ad litem, but that guardian ad litem did not do anything to help their case. So when our custody trial, the rehearing of this custody thing came up, they asked for a guardian ad litem to be appointed, because they were saying they had made false child abuse allegations. They said I think it was when he said I was beating my daughter because I was mad at him for taking me to court, which is a total lie. The guardian, you know, they asked for a guardian ad litem, and I said, well, Rachel Welty's already familiar with this, with our family situation in the case. Can we have Rachel Welty? And then Sarah Rice Digby tells the judge, oh, Miss Welty doesn't want to be the guardian ad litem in this case. And I'm like, oh, really? And then I talked to Rachel Welty, because she was there at the courthouse, and I said, Sarah says you don't want to be our guardian ad litem. And she says, oh, no, I'd be glad to be your guardian ad litem. So I go back in and I tell the judge, Rachel Welty said she'd be glad to be our guardian ad litem. And then Sarah Rice Digby says, yeah, well, she did say it was okay. Which is, she just admitted she was trying to get a different guardian ad litem because she knew Rachel Welty wasn't, Rachel Welty hadn't found bad things to say about me yet. So they wanted to get a new guardian ad litem that maybe they could push, maybe push harder, influence harder. So when the judge says, okay, well, we'll try to get Rachel Welty, and then they couldn't get her on the phone because she was in court. So instead of waiting till we could get Rachel Welty on board, they right there on the spot appointed this Charlena Pye Mack. I don't know if she goes by Charlena Mack now. I just call her Charlena Pye Mack. And she has been my daughter's worst enemy. Next to the judge. My daughter's worst enemy. So, but that was really nasty, the way Sarah Rice said, oh, we can't have Rachel Welty be the guardian ad litem because she said she doesn't want to be the guardian ad litem, which makes me look bad because, they're trying to say, oh yeah, she doesn't want to work with that crazy mother. She didn't exactly say that, but that's what she's trying to get across. But anyway, let's move on here. Okay, Magistrate Rosenberg then set the matter for further hearing July 14 to determine whether the child would receive a private or public education. On July 14, that's one of the few times they gave me something I asked for. It was ordered that the child would attend at Cole Elementary School, the public school close to mother's house. At this time, father non-suited his petition to modify the custody arrangement without prejudice, which means he was just putting it on the back burner till he was more prepared, had a stronger case that he thought he would be more likely to win on trial. However, mother elected to proceed on her counter petition to be named sole decision maker. And after they non-suited it, because I wasn't there that day, so they really sneaked around. She just pops up in court one day and asks to non-suit. And it was the day Rachel Welty asked to withdraw from the case because she was done with her stuff. So, and everybody tells me I don't have to be there. And I was sick that day, but I wanted to go anyway. And I got there right after. And I saw Rachel as she came out, and she says, oh, they non-suited the petition, so, and you don't have to have the trial or whatever. And I said, oh, they non-suited that petition, so that means I can homeschool again. And she's like, I don't know what she said. I can't remember what Rachel told me. But after they non-suited it, I didn't want them to non-suit it because I wanted I think Rachel told me that I couldn't homeschool without further orders of the court. So that's when I asked. I didn't know what a non-suit was, so I went and I looked, in the laws and stuff, what non-suiting was and how to get around that. And I filed a motion because I had asked for actually a lawyer told me that. He said if you asked for a change in one of your other pleadings, that's the relief you asked for. I can't remember exactly what he said, but I did what he said, and it worked. And the Sarah Rice wasn't there that day, so she couldn't argue with it. And so that's one thing I asked for and I got. So okay, so mother elected to proceed on her counter petition to be named sole decision maker. I already talked about that. Mother's petition was heard December 8th. Magistrate Robert, and it wasn't with Rosenberg. It was with Rosenberg wasn't there that day, so it was a different judge. Magistrate Robertson. So that's when they said they didn't have a material change of circumstance. And I also want to say this Magistrate Paul Roberts, I think it's Paul Robertson in Juvenile Court, Davidson County. And when we went in there, I told him, I said, the father has falsely accused me. He's made a false report. No, he hadn't made the report yet, but he threatened me. He threatened me. He said, I don't want you spanking the child. And I spanked all my kids, and I don't beat them, and I do it in a... I feel like I do it right, because I do it in a I don't spank him when I'm just like infuriated, and I spank him, and then I hug him afterwards and talk to him, and you know, because you can do. Of course, everybody knows you can spank in a bad way, but I felt like it was, and it worked well for me, and it wasn't my my first reaction. It was just one of several different things I used in disciplining my children, and people came to court and said, yes, mother's discipline seems to work, from people who've known me, all my kids, their whole lives. So, I never abused my kids, but I told Judge Robertson, I said, he told me he doesn't want me spanking my child, even though during my parenting time, it works for me. I've spanked her, I don't know how she was 6 then. And he knew I spanked my other kids, and he lied. And he claimed that, he says, if you spank her again, I don't want you spanking her. And if you spank her again, I'm going to make have the judge make you stop. I'm going to say you're beating her because you're mad at me. And so he said he was going to report me to CPS for child abuse. And and he called I spanked my daughter one day, and she was complaining about it. And that's one thing you have with kids, is sometimes they play one against the other. But she was complaining about me spanking her, and I spanked her for a good reason, and I didn't abuse her. And he said he called the police. She told me he called the police. 2 policemen came to his house and were talking to him about him not wanting me to spank her. And I think her bottom was red. This was hours after I spanked her, and there wasn't a handprint. But this was like 45. She'd been sitting in a car seat for 45 minutes, and she's got sensitive skin. Like, she fell asleep on my shoulder one time, and like in 10 minutes time, and her face, I mean, she had this big, just blazing red. I mean, that's how her, how sensitive her skin was. And she would get marked. You sit in a chair or you sit on the toilet too long, and you could see there's a mark there. But there wasn't a handprint. There wasn't fingerprints. There was not bruising. So, but he took her because her bottom was red from sitting in the car for 45 minutes. And he said that was from me spanking her. And he told the police, he wanted them to stop me from spanking her. And I asked Delara, I said, what did the police say? And she said, they just said, sorry, we can't help you with that. And but I told Magistrate Robertson, I said, he's lying about me. And he called these police in front of my daughter, complaining about how I discipline her, which undermines my parental authority. And when I said that, I thought Paul Robertson was going to do something, because he said, it's like, is that true? And then Sarah Rice Digby says, well, there was a call made, because they did report me. I spanked her later, and she says, I'm going to tell my dad you spanked me. And I said, no, you're not. I'm going to tell him myself. So, she's like, I'm going to tell my dad you spanked me, and he'll put you in jail. And that was really not nice of him, calling the police because he didn't like the way I was disciplining her. I mean, it took me weeks. It probably took me 5 or 6 weeks to undo that attitude she has. Like, you can't spank me. My dad will put you in jail. But we got it worked out. After, 5 or 6 weeks, and she was back to normal. And but Magistrate Robertson, he said, "Is that true?" Like, and I thought, thank you for being concerned about these false allegations and about this interference in my relationship with my daughter. And then Sarah Rice says, "Well, there was a call made," and she just really downplayed it. And I asked him, I said, would you ask him to stop making false reports about me? Because that was the second one, because he'd made one a few years ago. He claimed I had bed bugs, because I wouldn't let him come to my house because he threatened me and ripped posters off my wall that had Bible verse. I mean, my house, he comes to my house to see his child, and then he acts like he owns the place and can tell me what I can hang on my walls, and yeah, so there were some issues, and I just like was trying to set a boundary, and he didn't want to respect my boundary. So he's like, okay, well, if you won't let me in your house, I'll call DCS and tell them you've got your house is infested with bed bugs, and Dolores got bed bug bites all over her, and you're gonna have to let them in your house, in my place, and I'll show you how much control you have over your own life. So that was like a year or two before the spanking incident. And I told them, I said, this man is using you to harass me. He's using the DCS to harass me. Look, did you find any evidence at all of bed bugs in my home? Did you find any medical records of her having bed bug bites all over her? No. And her daughter, she had hives. I don't know what the hives came from, but they came and went. She had a cold. She had hives. Took her to the doctor. The doctor said, it's hives. And I'm like, well, are you sure it's not bed bug bites? And I knew it wasn't, but I asked that question because he brought it up. And she's like, no, they're definitely not bed bug bites. So he knew that. He knew that it was hives, and I gave her 1 dose of Benadryl, and they went away, and they didn't come back when the Benadryl wore off. So when people go to court and they lie, and the Magistrate Robertson, first he said, is that true? And then when he found out it was true, that Dolores' dad had threatened me, and I don't know if she was referring to calling the police to come out to the house or the DCS coming out to the house. But then he said, here's what he said. When I said, please tell him to not make false reports. Can you please ask him to stop lying about me? And he said, well, if someone believes a child is being abused, I can't tell them to not make a report. And my point is, he knew my child was not being abused. He knew she was not being abused. Just like he knew she didn't have bed bug bites all over, and I didn't have bed bugs in my house. So that was disappointing. But I did like Paul Robertson. Robertson. Yeah, Paul Robertson. I felt like he was a decent human being. And he was really patient with me because I didn't know what I was doing. And I told him, I said, well, I wanted to get through this. It was like 2 hours, and the real trial was like 5 days. I just wanted to kind of have some practice before I go upstairs, and I didn't expect him to reverse it. I hoped he would, but I didn't expect him to give me what I wanted. Okay. Mother filed a request for a rehearing, and that's when I went upstairs and had it with the juvenile court judge. Mother filed a request for rehearing December 9th. On February 25th, 2015, father filed a petition to modify and or establish a parenting plan. And that's when he's trying to cut me out of my daughter's life. The way our parenting schedule had been for years is I saw her. I had face-to-face time with her 7 days a week. He had face-to-face time with her 5 days a week. I had her all day Sunday, all day Monday. Tuesday night, she spent the night with her dad. I picked her up from her dad Wednesday morning, kept her overnight Wednesday. He got her Thursday overnight. I got her Friday morning, gave her back to him Friday night, overnight with him Friday night. And then I picked her up anywhere between 11 and 2 on Saturdays. And we did that for like since fall of 2011, I think. And it worked really well. It worked really well for everybody. My daughter never had to miss me. She never had to miss her dad. She could have called either one of us whenever she wanted to. it met her needs. It was kind of a lot of driving because we lived 20 miles apart, but we did it. We did it, and it was in her best interest, and she thought she had the greatest life anybody could have. But she was flourishing, and I wanted to continue that. And I think in his petition, he's trying to have me have not, every other weekend. I think that's what he was asking for. Okay, at the beginning, let's see. Father's petition was combined with mother's request for a rehearing, as well as several other motions filed by mother so that the court could address all issues at once. At the beginning of the trial, which was held several dates in 2015, concluding on August 28, 2015, it was stipulated by both parties that a material change in circumstances had occurred from the previous order of 2008, and that the material change in circumstances would require a change in the previously existed custody arrangement. And this is important because in this order, she says there's been no material change of circumstances, even though we stipulated. The guardian ad litem didn't agree, but the father and I both agreed there's been a material change of circumstances, and they knew I was trying to get primary custody back, so they didn't say, well, there's a material change of circumstances to change the parenting plan, but there's not to change, anything big enough to change custody. So it was the same, stipulation. We stipulated there's a material change of circumstances. You don't have to do a finding of fact on a material change of circumstance when the parties stipulate to it. And I got to look that up to see if there's any kind of case law, but common sense would tell you that. Or the rule, if I could find the rule about that. Okay. After trial, the court found father as, this is the trial in 2015. After trial, the court found father as primary residential parent and permitted mother's supervised visitation upon the expiration of an order of protection entered by the Third Circuit Court of Davidson County. That's what I talked about. I talked about that already. The order, our custody order was entered February, and we're confused about the dates, but it's October 2015. So that's what I appealed, and that's what I was appealing in this. Mother appealed to the Court of Appeals, although the Court of Appeals reversed a portion of the order. They reversed a unlawful gag order. The order as to the custody decision and mother's visitation was affirmed, except they read the Court of Appeals and their decision's online. If you look at my name, you could find that decision. But they interpreted the visitation as the supervision as only being 2 months. They read the order the same way I did, that after 2 months, if the visitation went well, and the person doing the supervising said we were ready for unsupervised, the unsupervised was going to start. Because that's important, because that was an issue later over whether my unsupervised visits were supposed to start when they did. But I like it that the Court of Appeals interpreted it the way I did, that it was only 2 months. If that 2 months went well, then I'm not supervised anymore. Okay, let's see. Both parties are now asking for this court to find that a material change of circumstances has occurred since the final order of 2015. We stipulated at the beginning of trial in May 2015, we stipulated about the order of, about material change of circumstance. Stipulated to it. Mother began her supervised visitation after the expiration of the order of protection around August of 2016. According to some of the visitation supervisors for Camelot, the visitation with the mother and the child did not always go well. During several visits, the mother brought up inappropriate conversations with the child. I deny that. Became abrasive during one particular visit, and I did become abrasive when this visitation monitor tried to end the visit early for no reason. No reason. attempted to leave the visitation area during another visit, and this is all in the trial. This is all in the hearings on YouTube. All this is just nonsense. As well as not abiding by the rules of the visitation. On one occasion, the police were called by the supervisor based on mother's behavior. Actually, the police were called 2 times because there's 2 different visitation supervisors, and both of them had only, there was the first day they had ever supervised us. And this is after we'd had 3 other visitation supervisors. Nobody ever said, you know, I presented any threat of harm to my child. But I'm going to run out of time here. I'm going to have to do a part 2. I can talk about that later. But yeah. So, but we had 2 visits go bad. Not because of something I did, but because of them trying to end the visit early, and neither my daughter and I had any idea why they were ending the visit, because the visit was good. The visits were going great, and we were following the court orders, and the visits were going great, and then they said, okay, we're ending the visit early. And I said, no, you're not. I don't agree, and I'm not leaving. So, but that was 2 times out of months and months, weeks and weeks, hours and hours. Like, out of like 80 hours of supervised visits, 2 hours went bad. And they're still holding that against us. Although Judy Mullins was the one that did the 2 months first, and she said I was appropriate, things were great, and we were ready to move to unsupervised. She told me that, and she told her dad that. And my daughter's dad didn't like that because he didn't want me to have unsupervised time. And he argued with her, saying, oh, you know, the mother's not appropriate. She told Delara her hair was dirty and she needed to wash her hair or something. And all these, the case notes are in where are the case notes? I've got them somewhere on Facebook. Although Judy Mullins testified that she did not, and Judy Mullins' testimony is on YouTube during the hearing. Although Judy Mullins testified that she did not have many difficulties with the mother during her visits, Camelot as an agency was not successful in supervising visits of mother. Because of the complications caused by the mother during the latest visits, Camelot was no longer willing to provide the supervised visits, nor did they think the mother demonstrated a readiness to transition to unsupervised visits. That's a load of garbage, and Connie regularly did a really good job getting the truth into the record, the truth that the judge does not want to acknowledge, about the father's interference in our visitations and going around talking about me behind their back and putting all these restrictions, asking them to put restrictions on me that the judge did not put on me, and intimidating the second visitation supervisor we had. He didn't want the first one because she said I was appropriate. So he got a second one, and she was really intimidated by him. And but I liked her. She was good, and she felt like I was a good parent. And that I didn't present any threat to my daughter. Okay, I think I'm going to stop there, and then I'm going to pick up in a minute. Yeah, that was 17 on this list. I'm going to stop there.